Good morning, everybody. I'm going to reconvene the Committee of Conference on House Bill 1127. We did call for a recess on Tuesday to get some legal advice and legal opinions. So I guess it would be beneficial to start with that. Is that the attorney you were speaking to in it? If you want to come up and give us your opinion.
I'll do my best.
Can I have you state just your name?
My name's Richard Lehman. I'm the legal counsel for the Senate.
Thank you.
Starting on section 9, line 27 of the draft amendment appears to create a anomaly where New Hampshire DMV would issue a license to a person and permit that person to drive in New Hampshire, but the same person of the same immigration status who obtained a license in another state like Massachusetts or anywhere else would not have that recognized here. So it seems like those two things don't fit together in a way that is immediately rational. The section 7 of the amendment, I think, works to an extent, except that it excludes a class of people who are lawful but not permanent residents, like people with student visas and other non-permanent visas. Now, I believe those people could get a New Hampshire license if they wanted to, correct? So you're not excluding them entirely, but it would require that additional step for out-of-state students on student visas who come to New Hampshire, which is something that's been discussed in the past anyway. So I think that section 7 is workable and section 9 less so.
That's interesting because section 9, with the exception of the words notwithstanding, RSA 26340A, is current law. Is it not?
I believe it is, but it works sort of hand in glove with the section that's being notwithstanding, is how I understand it.
Any opinions, any comments?
I just briefly, I think that as Attorney Lehman has summed it up, I don't see this as being at all workable, and certainly not at this late hour to try to put in this kind of an amendment.
Well, if I'm not mistaken, if I hear you correctly, because of the change from lawfully present to lawful permanent residency, that creates the anomaly that you're stating between what we're allowing New Hampshire residents to do versus out of state.
No, I don't think that is correct. That's the difference between lawfully present and lawful permanent resident is just narrowing the category of whose license will be recognized. It's the 26340 section that I think creates an anomaly.
Anybody?
I guess what I'd suggest is that if we want to move forward with the out-of-state driver's license provision, which we attach to 127, that we vetted and think it's workable, that's probably at this late date the best option for all of us. And I'm just looking, I know that the House rejected it, but it was seemed to be 176 to 174. So I know you're trying to find a compromise, but
Actually, compromise, yes, but actually I was trying to make the bill do more because again, like I said and explained, the difference between lawful presence and being here legally, it's two different things. So if I'm hearing you correct, you're not going to support the amendment. You would like to see the original language of 358 move forward. Is that what I'm hearing?
that would be my suggestion.
And I'm not there. And here's why. You just mentioned 176, 174. There's a definition of insanity, you know, when you keep trying to do the same thing over and over and expecting different results. For me, I was willing to take another shot bringing this to the floor with an amended language because I'd have something to argue that it actually does something. But I'm not willing to take this back to the floor with the same language. It makes no sense to me. So that's where I'm at with it. I would more at this point, because I am not dying on the sword for this. Just for the public record, I did put what I thought closed loophole for even people in New Hampshire that would have matched what Section 7 does, and I think might have removed the anomaly in Section 9, but that bill was indefinitely, not indefinitely postponed, but interim studied in the Senate. That would be House Bill 1118. So now we are at it, bits and pieces of something that's going to accomplish nothing. So I don't know if you'd like to chat for a minute, but that's my position. I'll even put it to a motion if need be, because again, I'm not falling on the sword for this, and I'm not bringing it to the House twice. I'll make the motion that the House accede to the Senate position upon further amendment, and that further amendment is to remove all language related to Senate Bill 358. Is there a second for discussion? Okay. Well, what say you?
Just, and may I just ask a question before? So you're suggesting that we just, the only thing be included is the original language of 1127? Thank you.
Okay, where are we at?
Thank you, Mr. Chairman. We would like to respectfully ask for a recess to this afternoon. We're gonna see if we can try to reconcile that particular language that you are speaking of. And we just need some time to do that. So is it possible to do that? Cause we're maybe, at 11? Okay, 11:30?
16:30.
Oh. Okay.
I think you could come back without us.
Okay. Okay, I can come back without them and,
I know we're all busy.
yes,
And I did bring a draft amendment here to try to expedite things. We had the conversation about some of the issues that we had in possibly creating the holes at our last meeting. And now you're asking to come back again in another 2.5 hours.
Mhm.
Let me check 1 minute.
So I
Okay.
think that the purpose of that would be, unless we have a solution you can agree to, that will accede to the House position.
okay, and
That's what we're,
that's what we're gonna try to do.
Thank you. Thank you, Mr. Chairman. I understand that everybody's trying to work towards a place that works, but these are complicated, difficult issues, and it's really worrisome if we're going to try and fix them in a couple of hours with all new players. And it's hard for me to, see that that's
Oh.
the way to go.
so let me just repeat that. If we can't get something everybody agrees to, we're prepared to accede to the House position,
And there would not
which
be,
the House position is the base bill, 1127.
so just to, again, clarify, there won't be new people sitting here. They will be in a different committee conference. I will be here. I will have the authority to say, we're going to accede to what you want. But we just want to have an opportunity, to see if we can really focus in on that particular section and see if we can get some sort of resolution.
Okay, fair enough. We can take a break till 11. I'll confirm that this room is available, but at least if not, I'll find a different room.
Okay.
But before we do go through this motion, do you know or have any indication if whatever solution you're coming up with is actually germane to 358? Because we operate under
Yes,
some
It has to be.
some rules.
We know that.
Okay. All right, well then,
Okay,
11
thank you.
o'clock, and
Thank you,
I'll
Mr. Chairman.
tentatively plan for this room. If it's not, we'll post it somewhere, what room
Okay.
it's in. Thank you.
Thank you.
Again, we'll be on break till 11.
Thank you.
Thank you.
So once we're settled down here, I think we can,
How are you? What was that accident?
Yeah, it's
Oh,
one
you
of this
didn't
room.
see it. No, but
Let's go back to 103. It looks nicer over there.
so good morning.
Good morning. How are you? Good
I'm
morning.
doing well.
Good morning.
So it being 10 o'clock, I'm going to open the committee of conference on House Bill 518. And welcome everybody. Thanks for being here.
Thanks for having us.
Okay, I know, going to let Representative Grota start out because she was, I think, chairing the subcommittee work session that dealt with some of these issues, so.
So on the side by side, thank you, Representative Lucas. If we look at starting on page 39, I believe, the Senate added their language to House Senate Bill 485. And Senate Bill 485, when it came to us, to the ED&A committee, was very similar to a bill that we had heard earlier, House Bill 1385. So when we received Senate Bill 485, we took out the similar languages between the two bills. They were both dealing with the fast tracking of military individuals with for licensing. And the only two issues that remained on Senate Bill 485 were the digitally verifiable licenses and, excuse me, the part of the bill that addressed that, and this was an important part that was in the Senate bill but was not in the House bill, and we left it in the Senate bill. It had to do with those licenses that are under the responsibility of boards that do not report to OPLC. And they should also have this fast tracking mechanism. And I believe the RSA that's referred to as 327G. And that we left that in the Senate bill. Now, I don't know, I think Senate Bill 485, the version that we sent back, was attached to, for one reason or another, I don't remember, but it didn't make it back to the Senate. And I don't know why, I don't remember, I'm sorry. So when you added this language back in to this bill, because it's important, you added the Senate bill in its entirety, as opposed to the version that we had noodled out the differences between the House bills. House Bill 1385 has gone through the Senate, passed the Senate, and it's on the way to the governor's office. So that language already exists as a statute. So we just want to make sure that if we were to adopt the House amendment to Senate Bill 485, which really only deals with the boards that are not under OPLC having the same fast tracking mechanism, that's advisable. And then as far as the digitally verifiable licensing, we took that out because when Commissioner Goulet came to speak to us in the committee of conference, in our subcommittee, he indicated that they don't have the software or the mechanism to do this now. So it's not something that we can initiate, but it is something that they're looking into. And we had one, during the hearing, we had one private individual testify that their company could do that, but we don't know if that's the only company can do that can do it. Are there other people? So we chose to, and they were promoting their mechanism and their software. So we didn't know how we should examine that in relation to the fact that we don't have that software.
And I just add one thing that we got testimony on, and that is, I think the information on whose license is already online on the OPLC site. So that is readily available, arguably digitally, but not the technical, digitally verifiable license. Representative Manchaputi?
Thank you, Mr. Chair. Thank you to letting me add in very specifically, Commissioner Goulet did mention that there's a whole, again, like we talked about, whole transformation of website access, online access. They are making that a more uniform across all offices and, website looking very similar. So, and access also. So that's in the process. It's not ready. Right now, if we incorporate this, it would be, how do you find that in the weed? So it's timeliness of putting that digital verification. That could be something that could, once this happens, the infrastructure is ready, then that could be added easily. That was the discussion.
My apologies, I'm trying to find my committee report.
Excuse me, I'm looking for that amendment on my,
For which?
for,
To 485?
485. I'm looking for the amendment number so that we can,
I've got it here. It's 1610. I've got one copy.
okay, so if you could just kindly show it to,
Yeah, this was the House amendment to 40.
No words. It's, I'm sorry.
Oh,
What was
sorry.
the number of the amendment?
1610.
1610 to
H.
480. I had 45. Okay, 1610.
And that's the one, the committee amendment, not
I
the
know.
floor amendment that was added.
mhm.
I don't see that on, oh, I'm on the wrong one. Yeah, I don't see that amendment on the general court. Oh, no, never
It
mind.
was to 485.
My bad.
Yeah.
1610.
And if anybody needs it, I printed one copy of 1385, which is.
Got it.
Sure, yep.
So as I recall from I'm trying to recall our hearing on House Senate Bill 485,
Mhm.
which was a very long time ago. And I'm trying to recall some of the information of it. Would you be opposed to bringing Mr. Osterhout up for a
No,
moment?
that's fine. Mr.
Also,
Osterhout, oh,
I can come over there. I have it pulled up. Hang on a second. Let me just come over there.
so Mr. Osterhout, if you can come up, I think we have some questions.
Good morning, Douglas Osterhout, OPLC.
Okay, if you have questions.
All right, thank you. Good morning.
Morning.
Good to see you again. It's been a long time. I'm trying to go back and recall here some of the testimony on 485, and I don't have that in front of me. You have, as I recall, I think Director Courtney testified on 485 when we had this, and we were discussing the digital verified portion of that. Can you refresh my memory just a little bit on that?
So I think the digitally verifiable piece was a little fuzzy at the beginning because, as Representative Lekis has pointed out, we do have a way to verify licensure on our website right now. We weren't sure if that met the definition. We were working with Commissioner Goulet to kind of see if this is any different, if it would require other things. And I think, as Representative Kuroda said, in working with Commissioner Goulet, he came out and said, this is going to be a long, tedious process. It's going to cost a lot of money, and we're just not quite there yet. I think our expectation is that within a few years, this will probably be a standard thing, but now is not really the time.
Okay.
Yes, Senator?
Thank you. Is there an interest or a proposal being worked on in your office to propose a budget item for next year to do this, or to evaluate some of these software options that Representative Grota was talking about, so that we could move towards this kind of digital verification?
So that's probably a question better suited for Director Courtney. To the best of my knowledge, there is not,
Okay.
but I can't say that with 100% certainty. I also want to point out that if something like this were to be implemented, it would probably be a DOIT
Mm-hmm.
project, not necessarily an OPLC project. We would work with DOIT, but it would be on them. And then the finances we would have to work out, but it would be DOIT who took the lead on that.
Okay. Thank you for the clarification.
Representative Montepudi?
Yeah, if you could clarify, like I put it, infrastructure to verify doesn't exist outside of OPLC is the infrastructure, IT infrastructure that's needed to verify digitally is what the Department of IT is working on, and with the website and the software. And once that is ready, OPLC can do the digital. Am I correct?
I think so, but I think to answer that fully, I would have to speak for DOIT, which is not something I can do. I can say, right, there are kind of two pieces. There's the website that we maintain now where you can look up to see if somebody's licensed, if they've been disciplined. What happens outside in the DOIT realm was a bit out of my purview.
So, thank you. So, I mean, that's the reason why we removed the digitally verifiable licensing part of it. Representative Grota, as I recall, the reason your amendment also took some other pieces out was because they were in 1385, is that correct?
That's
Yeah.
correct. It's correct. They overlapped with 1385. So there were two things that I'm remembering now because I'm reviewing my notes from the subcommittee work on 485 and the amendment itself. A definition of what digitally verifiable licenses is part of the issue because there are many ways of digitally verifying things. The process, Scott Withrow is the individual that spoke at our hearing, and his company has a process that is the ultimate in digitally verifiable licensing. And is that what we want as a state, and do we want to invest in that, as opposed to what are our expectations of what digitally verifiable licensing is? And because there's a whole plethora of software, we felt that, and we didn't have any of it, we felt that we should pull that out because one, we can't do it, and two, we need to figure out what it is that, and that's why I know Director Courtney was going to work with Commissioner Goulet on trying to put some definitions on that. Is that what you recall?
I do recall that, and I somewhat alluded to it about, I used the term fuzziness. That was actually what I was trying to say. It was articulated better.
So, one question. Is there a standard for what a digitally verifiable license is that exists outside of New Hampshire? I mean, because for it to be digitally verifiable, somebody else, presumably not New Hampshire, is going to want to make use of that. But if there's no standard that is generally recognized, what would that mean?
That's an IT question I don't really have an answer for.
Right, and we didn't get an answer to that, in the public hearing or as far as I know afterwards. So that was part of our concern. Representative Grota.
So Senator Pearl, and I guess I'm speaking to the Senate, is your concern on the 485 portion of it, the inclusion of the digitally verifiable? I'm trying to figure out, do we agree that this subcommittee work that took Senate bill, that took the components of House Bill 1385 out of Senate Bill 485 is no longer, we're in agreement there, and that digitally verifiable licenses is what we're trying to noodle out here?
Well, I think we're getting there. Because
Okay.
you had very different testimony than what we had on.
Yes.
Figured that might be the case.
We didn't have any of this discussion, and so that's why we're trying to get up to speed real quickly.
Okay.
On
Yes.
what you're giving us information we didn't have.
Right, okay.
So
Yeah.
that's why I asked that Mr. Osterhout come up
Sure,
and I guess if I may ask one more question.
certainly.
So are you feeling like that the House version of 1385, it was 1385, right?
1385, yeah.
The House version of 1385 covered all of the other components of Senate Bill 485 without the digital portion?
I would say yes. So one thing we did, because we were working on these bills sort of in tandem, is when we finished the language of 1385, Director Courtney, Representative Carol Brown, and I believe Colonel Perry, we did a crosswalk all together. I was involved behind the scenes too. We did a crosswalk to make sure we weren't missing anything, and everyone was satisfied that the components that we were pulling out of the one bill were contained in 1385. So that's a long-winded way of saying yes. I think we're satisfied outside of the digitally verifiable piece.
So the only portion of 485 that isn't in is the digitally verifiable piece.
Yeah,
Yes.
I can see that
Wait,
written,
oh,
we have
wait.
written confirmation outlined.
Representative Grota.
Page 41 of our side-by-side.
Yep.
This paragraph is notwithstanding in general or special law to the contrary. Wait a minute, sorry. We have, there's a paragraph that was not in 1385 that is, was added, was what this house amended it to, and that's 1610.
That's what you've got. Yeah.
The training, education, and service would constitute military education, and this is the part that I'm trying to find in the side by side.
I see, it's
Yeah,
in,
okay,
here it is, right here, in,
Where is it? Oh,
it's in line.
to the bottom.
This is the language,
She's
but
on the
this is,
side,
yeah, but this is the language that they put into,
45.
1385, it's right here.
And then we have the amendment paragraph 332.
Notwithstanding any general or special law to the contrary, so part 2.
Not-
So this
there-
language, we could get rid of this because it's, this is already going to the governor, all of this.
Okay.
I would just recommend making sure that the amendment. Excuse me, I would make sure that the wording from Amendment 1610 is added to Senate Bill, to House Bill 1079, so that we make
Five-
sure,
518.
518.
We're dealing with 518.
518, I'm so
Yeah.
sorry, I got too many numbers on my, apologies, let me start over. I would recommend that the Amendment 1610, which talks about these
Military education.
yeah, that's portion of it is what we add to House Bill 1518. This part is very important and was in Senate Bill 485 and was not in 1385.
So there's this one small piece.
Correct,
That's
exactly.
485 as it came out of the House.
Right.
With the House amendment.
The
So,
remainder of 485, I'm sorry.
yeah, no, please.
The remainder of 485 is in 1385 except for the digitally verified portion. I'm just
Yeah.
trying to make sure I got that in mind.
Yes, exactly.
Between the two, adding this amendment covers everything, and we still leave digital verification on the table for next year to define and fund. Is
Correct.
that's the motivation here.
Correct.
Correct.
All right, that's our next step, is to figure out how to digitally verify and move this and close the circle on
Right,
this
right. And
project.
I think before we
Yeah.
do that, we'd have to get together with Director Goulet.
Right,
And
that's-
sort that out. Yeah.
That is not a today, that is not a thing we can solve today.
Yeah, no,
Yeah,
no.
okay.
Taking notes. So would it be your proposal that we use this amended language to add to
To take 518 without the
without
Senate
the
amendment and add that to it, and that's what we would do for now.
and we'd have that bill?
Yeah.
Okay.
I have a question. On page 5 of the side-by-side, the or in matters appealed pursuant to RSA 31014 until the office has issued a final decision. This is the temporary licenses.
Yes. And this is
Um,
fine. I don't believe this is
I
an
mean,
issue for
yeah, We
us.
could, in addition to
Okay.
language in 1610.
Yeah.
Add some of these other changes. I looked at a number of them. The one on page 5 was fine. There's
Okay, so keeping in the temporary license so that people can move forward while we're evaluating them.
Correct.
We can do
Right.
that? Okay.
I'm
gonna
fine with
check
that.
off.
And also on page 9, there's another change, which is just this
Uh-huh.
section. I mean, it's sort of a language
It's
tweak,
redundant,
which
but I mean.
I don't have a problem with that,
All right.
certainly.
I'm gonna check that off.
And then on page 11 of the
11.
side-by-side, the first one is just a fix we missed, I think, from board to office, yep. And changing the notice requirement to, instead of having it in here, refer to, the RSA 5.8. I mean, you're fine, everybody's fine with that? We can leave, yeah, we can leave that, that's fine. Yeah, I looked through this, there's another one here on page 14. Yeah, actually, that's one I had a question about. I think our language was they cannot meet quorum, and the Senate changed to lacks sufficient members to. And I have a guess as to what the motive was behind that, but I don't know if you could speak to that. That's fine. Page 14. I mean, is that an issue that they can't meet quorum? Could be because for a particular meeting, they couldn't get everybody there or enough people there?
We had
Sure.
a number of conversations with a multitude of boards who were struggling with getting quorum, and there was, I don't know, senators, if you can refresh my memory, there was some discussion about changing quorum to being 50% plus one in order to be able to conduct business for a number of boards. This could have been one. I'm going to look at the
But this
hearing
is a more
report.
general, I mean, this is a more general,
I guess, the Senate version lacks sufficient members to meet quorum. It really narrows the parameter.
Right.
So that the only reason that the executive director could do this is if there's lacking sufficient members, rather than any other reason why they couldn't. meet
Well, like the
quorum, which
first
I don't
one.
know what that would be.
well, I
honestly.
mean, thinking about it myself, I thought of the situation for one particular meeting, they couldn't get enough people to attend, although there were enough members who were appointed and confirmed. And so that would let the executive director take over just because one meeting they couldn't do it. And yeah, your version tightens it up, which I'm
Do-
okay with, actually.
Okay. All right.
Yeah,
Okay.
yeah.
Just to clarify, so the quorum requirement for each meeting versus per meeting, your Senate version gives that leeway to say for each meeting
Each meeting.
versus quorum requirement for the entirety
Yeah,
of the
they
board.
just can't get people.
Yes.
So I mean, that's everything. I think we're fine with all the changes the Senate made up to page 27 in the side-by-side.
Right, maybe the Senate can explain what the changes, why they added this to the disciplinary portion. And whether or not, I'm just concerned because
What page are you referring
I'm
to?
on page
Starting at
27.
27.
Because in 20, when
This
we
is the
did House
disciplinary
Bill
action.
655,
Yep.
and we made a lot of changes to the disciplinary actions overall, and I just wanted to make sure that this doesn't conflict with that, or what the reasoning was thinking about, and maybe Mr. Osterhout can help with that, because this
So-
is
So
obvious.
those are the changes from page 27, the side-by-side, up through the top part of 38. So,
I don't have a copy of that bill in front of me. Is there
the
anyone?
bill or do you have a copy of the side-by-side you can let him look at?
Doug, if I remember correctly, this was the amendment that Senator Perkins Polka brought in, if I'm not mistaken.
Yeah, I didn't see it listed as a separate amendment, I didn't.
Well, I think she did it in our committee, amended the bill in our committee.
Okay,
This is language she changed.
it was
But I
part
may
of,
be
it was
confused.
part of a larger amendment, maybe?
Well, I think it was part of a committee
Committee
amendment,
amendment.
Okay, part of the committee amendment, all right.
I think.
So the amendment that Senator Perkins Cloca did. So we had made the ask. We're finding not a lot of value add from being notified by insurance companies, by court, getting complaints. Where there's a lot of redundancy. We have to make sure that it's getting paired, and for complaints and just enforcement purposes, we weren't finding a lot of value. I think Senator Perkins Cook, I can't speak for her, but was a little uncomfortable and maybe had some conversations outside where she wasn't quite comfortable getting rid of this language quite yet. Maybe something we look at going forward for next year.
This is what we added back.
This is what we added back.
Yes.
So the OPLC had asked that it be stricken, and Senator Perkins Cook was not comfortable with that.
So does this conflict with any of the other changes, 655 or
This would
anything else?
maintain status quo.
So, and what does this actually do? What's the effect of this?
Of the language in
Yeah.
the statute. Oh, when individuals licensed under the Board of Medicine are part of a court case or a settlement agreement, the board, the OPLC is notified.
Okay.
So that would just keep that notification in place.
And OPLC didn't feel that had much value, or?
Not really, because we're getting the same complaints. A lot of times the insurance complaints is we don't necessarily have a lot of facts or information to work off of, and we could get a list of names of individuals, and we don't know who was involved in what piece and what part. So there's not always something we can act on in that, say, notification from an insurance company. So we're not particularly. There's just not a lot of value from our perspective when we have the complaints, we have the notifications from the courts, those types of things.
Representative Groda?
So I'm just wondering if this came out of the concerns that Senator Perkins Cook had because we eliminated the medical review board, right?
Yes.
So in eliminating that medical review board, what we're saying is we still want an extra guardrail when it comes to medical claims, especially since what's happened at Catholic Medical Center. So it's just an added, and I understand that concern. And if this is language that adds a safety to that procedure and it doesn't conflict with language that we've already put into place, then it's okay. And if we find that we don't use it, we don't use it. But at the same time, it's there. So I do understand the concern.
I understand. If they don't find it useful, my inclination would be remove it. But if the Senate feels strongly that it should stay, I'm okay with that.
Great, yeah, given the removal of the medical malpractice review board, there was a intense interest to keep reporting by malpractice insurers and courts to OPLC because it's not going anywhere else.
Okay. So what I'd like to do is keep going through
If you don't need it, but put it in a box and we'll come look at it when we need it.
So where does is the digitally verifiable portion start on page 39?
Yes,
Section 15?
third box down,
Section 15.
yes, this
So we want to strike,
So
part. So
what-
this is already in 1385.
So,
And this is who couldn't figure
so
out
that's,
how to do it on the fly. And it goes
are we correct on
to,
that, Doug, that is the digital verifiable portion starting on page 39, I'm sorry.
yeah, the bottom part in 39, that runs to the
Section
top part
15
on,
of the bill.
43.
43, right?
Yeah.
And just so we say it again out loud and I'm remembering all of this, I think I'm looking straight at House Bill 1385, which has already gone to the governor. We've covered this.
Yep.
Yes, we have no reason to believe he will veto this.
No.
No,
Represent-
no,
No.
it's not controversial.
Representative Montague, yeah.
Thank you. The digital verification is not.
Except for the
Yeah.
Yes.
everything else, the extension of a temporary license so that people can get right to work is all in there.
Okay.
So would the House be amenable to accepting our amendment, and we're removing section 15, starting on page 39, all the way through the top of 43, and then we'd leave, and then we need to add,
Well, there's three other sections side by side I'd like to go through just as
Oh, okay.
briefly.
Yep.
So on page 38, section 12, this is inspectors. So you wanted to change the inspection on barbershops, salons, barbershops, and schools from once a year from twice a year? Is that the middle of 38?
Can I speak to that?
Yes, please.
So, this is one of those things, this was at the office's request, and essentially right now in statute, we're required to inspect every shop in the state twice a year. The office had actually asked for this to be stricken from the statute, but there was a lot of discomfort, right? That's sort of what was the term used? The kitchen's only clean when company's coming over kind of thing. So we went back and our intent was originally to do this in rule. And this is sort of the negotiation between doing it twice a year, which is really not something we're capable of doing with the amount of staff we have right now. And making it once a year, the idea being one of those would be tied to licensure and licensure renewal, and the second would be sort of that drop in just random inspection to make sure people are abiding by rules and statutes. So this was the negotiated piece, because right now we're required to go twice a year.
Ah, okay.
So in a 2-year span, we're
I was
visiting.
thinking
Yeah.
I was thinking every other year, but no, it's twice.
No,
a
no,
year.
it's twice. So
okay.
in a 2-year licensing span, we'd be in your business 4 times.
Okay.
This would make it once a year. So
I mean, does
we'd be
anyone
there
have an
twice.
I'm fine with this. Okay, so that one's fine. And then the next one, the bottom of 38, running to the top of the next page. Okay, so this just changes sector of,
I can speak to this
okay,
one too.
please.
So when Director Courtney, when she originally came and recruited me and got me on board, her intent was to have sort of one attorney who oversaw the legal component of OPLC. For various reasons we've discussed, that didn't work out. We created a separate branch, but she really wants to go back to that original idea where there'd be the executive director, there will be one sort of chief legal person, and that person would oversee attorneys for the agency, attorneys for the board, rule writing, and hearings. And it makes sure all these people with these legal component are ultimately going to answer to an attorney supervisor. Currently, Director Courtney has some of these people answering to her directly, which is okay because she's also a lawyer and sort of has that understanding. The executive director may not always be an attorney. So this kind of puts that safeguard in place. And then simultaneously, because we had these 2 positions created in statute last year, the chief and the agency counsel, modifying that board counsel chief position to a chief of staff position, because the executive director right now has a lot of responsibility, and I think the people who work with her day in, day out think there are certain responsibilities she could be delegating. And this would be that sort of chief of staff position that would take on and let that director get out of the weeds and things like personnel matters and those types of things. That currently doesn't really exist in our office.
Okay, look, and the next one on the middle of 39 looks like it's related. Is that?
Oh, that was the second piece that I was.
Okay.
Yeah, and then that box 14 is just saying both of those positions would answer to the executive director.
All right. Does anybody have an objection to? I mean, I don't. Okay. Representative Simon.
I just need to ask Mr. Osterhout if he needed to declare a conflict of interest in this testimony.
I can't presume I'll be put in that position, sir.
Okay, so, I mean, my understanding as it stands actually is we would take HB 518 as it came out of actually with the Senate amendment, but removing the amendment to section 15, and then adding in the language from 1610. And, okay, and then there's a procedural question. I've been on committees of conference. I haven't chaired one. At this point, do we actually need to get an amendment and vote on it? or vote on this intent and we'll get the amendment.
We vote on the intent and then you draft a committee report reflecting that.
And I'll go down to OLS and get the
We have all
amendment.
us and-
And we all sign off after we read it and,
Okay,
yeah,
cool.
so.
But we have to vote separately, the House. 'cause
Yeah, I
the
understand.
House
That
votes
one
on
I've-
your
I've
part,
seen.
the Senate votes on
So
yours.
anything else, Representative Groden?
No, I would make a motion to the House members that we
Okay, you guys are gonna go off.
accept
and-
that.
May I ask a question before we do that?
Yes,
So there is language, we're talking about an amendment to 518.
correct.
Okay, there is language in House Bill 518 and House Bill 1622 that modifies the same statute, RSA 3108. We worked in the Senate with DOJ very closely. We would like the language in 1622 to be the language.
So is
that-
this the language that's in the amendment 1610? Can I?
So I
move that
don't
back for a
think this,
moment?
I think it passed both the Senate and the House 518 and 1622, but it didn't get changed in 518.
Okay, can I just make a comment?
not sure
We have a
which-
committee of conference this afternoon on 1622.
We
Representative
like
Pearl.
the language
Senator
of
Pearl. Can I see
1622.
that?
We want to make sure the language of 518 doesn't conflict with it. And if it, we don't want to end up in sort of a signing race.
So,
So
is-
what we would like to do is take the language from 1622 and we want that ultimately to
but
be the
what, I'm not, just my confusion,
Yeah.
I'm not sure exactly what language you're talking about. Is it
Yes, I do.
the
I think
332G
that-
language or?
So in House Bill 518, I'm looking at the actual bill as amended by the Senate. Page 2, line 14 through 18.
Just a moment.
Mr. Chair, is it on side by side?
Oh, no, he's,
I don't know if it would be
You're
in the
talking about
side-by-side.
1622 right now?
well,
518,
it won't be,
well,
in
that's
it won't be in the side by side if.
'Cause it
if
wasn't
neither,
changed.
if the Senate didn't change it.
So in House Bill 518, as amended by the Senate, it's on page 2,
Yeah,
beginning in line 14, going through line 18.
Can you just give us what the words, we don't have line numbers and what we're looking at, so
I
can you
actually,
just tell?
I actually do.
It's RSA 310-8, Roman numeral 2.
Oh, yeah, that's a different, we have appealed RSA 31014.
Oh, I pulled mine off the website. I'm not.
Well, actually, I got it. I mean, this is section 3. I mean, I printed this off the website. License renewals lapse, 310.8. And the section you're talking about is Roman 2.
Correct.
And what it says is,
Two.
licenses shall be valid for 2 years from the date of issuance, except for those apprentices licensed for 1 year in accordance with rules adopted pursuant to 541A, provided that timely and complete application for license renewals by eligible applicants shall continue the validity of the license being renewed until the office has acted on the renewal application. And that's existing language, and it adds, or in matters appealed pursuant to RSA 310:14 until the office has issued a final decision. It's that change?
Yes. So in House Bill 1622, Section 1 modifies the same paragraph, and this is the language. I work with DOJ on both of these,
So
but
it's different language?
it is different language. I can read it if you'd like.
Ju-
Yes, sir.
Could we just strike that entire paragraph right out of this bill?
I think so.
And then there'd be no change
I
made to it in
think-
this bill?
There'd be no
I'm
change in
actually-
518, and then 1622 would
And
become the language.
1622 would prevail.
I'm
believe
actually
so.
looking at section 3, which that's part of, and that appears to be the only, oh no, it's repealed and reenacted, but really,
Hmm.
for section 3, is that the only change that this is making? It looks like that. In which case, we can just, the amendment could just remove section 3. Reverend Simon.
It could, assuming that 1622 for whatever reason doesn't go down in flames this afternoon.
Right, so I'm looking at to see, let me just look to see what 1622 looks like before we go. Yeah, let's, just one moment, I'm looking at that, because I know I'm on that committee of conference
I
this
mean, the other
afternoon.
option would be to put the 1622 language in here, and then in 1622, you could pull it out.
What is
Was the-
1622?
I don't know.
So was the only change to that, the language that we added?
So what we're looking
back
at
in-
is
This
license renewals.
No, we changed that totally
Which,
from the Senate.
I don't remember.
1622.
I don't
think
remember
that's
that one at
totally
all.
different
I
than
forget what that one's about.
Three. So, yep, interim
Oh, no, that's
license
the
renewal. lapse.
Doug, what was 1622?
1622 has to do with the notification of rulemaking. Remember, this is,
What did the Senate change? What would they-
I'm looking, just a moment. I see a House version and I see a Senate version. And the Senate version has the part about license, the first thing is about license renewal lapse. So we just have to make sure that and they do talk about the notification of rulemaking. So we just have to make sure that in the 1622 committee conference, we leave that paragraph as is. And I believe Senator Pearl, you're on that committee with me. So we're gonna make sure that I'm gonna circle this paragraph and make sure that we keep that in 1622 and we take it out of here, okay?
So that's the entirety of section 2, Director of Legislative Services, Publishing Amend.
No,
Or
it
say, or
talks
are you
about
talking about part
it's
two?
license renewal lapse.
Right, underneath that, though. Just that one paragraph?
It's Roman 2.
Yeah,
Just Roman 2.
yes, the
I see.
license shall be
Okay.
valid, yeah.
Would it make more sense just to take that language and put it in here to be safe? And that way there's no conflict, we have consistency between the two bills?
You could strike it on the 1620.
Okay, it's fine. Oh, yes, just in case
Just in
something
case.
happens,
I
okay,
have
so
no
we
idea
could
what's
do
gonna
that. Can you keep track of all the stuff?
Yeah, I'm making notes. That one I gotta figure out I gotta find it, so I can get to, Representative Mangiaputi while I'm,
Thank
So
you,
you want me to
Mr.
just
Chair.
forward this to you?
if
right
you
now?
would.
Yeah.
Thank you. Yes?
You know, in 1622 Senate version, it also refers to RSA 310:8 and is repealed, 2 is repealed and reenacted. So, right? And then it refers to RSA 541-8, that's the rulemaking RSA. That So that
Talks-
won't change, and the only change that we're seeing is the RSA 310:2.
I would be very careful about that statement because this bolded language was changed from the bill as proposed, but I don't have the language of RSA 310:8 in front of me, and I would say it would not be my style to repeal and replace the whole section unless there were other changes, but they would not be bolded because it'd be considered new language. So I think the safest bet would be take the language of 1622, that paragraph 2, drop it into 518, and then
Yep, so we're
we should
basically,
end up with the language
we're
we
gonna
wanted.
replace licenses shall be valid for 2 years, until the office has issued a final decision with licenses issued by the office shall be valid for 2 years from the date of issuance, The licensing terms established by this section shall supersede any conflicting terms established in the statute as administered by the board listed in RSA.
You're reading that from, is that 1622 as amended by the Senate?
Yeah,
And what page and line is it?
it's on page 1.
Okay.
It's right on section 1. It starts with license renewals and it's paragraph 2. Licenses issued by the office. I'm looking at amendment 2020.
Yeah, I just looked up HB 1622 and it's showing, there's something wrong. They're showing no amendments even though they adopted amendments.
There
Like,
are 2,
Well, I see them right here.
really?
1226H or
Yeah,
1724
Right.
25, Go
77.
back to,
You want to look at
May
my,
15.
well, I want to make sure I can find it so then when I go to OLS, I actually have something I can point to.
Mr. Chair.
Yeah,
Hey Doug,
yeah.
it
but I-
appears in five
he
eighteen
wants
that
to
we've
find it
listed
on
the
his
whole
phone.
section
No, I
of
understand,
310:8,
so
but we've
this
only made a
is-
change in
Senate.
paragraph 2.
It's amended by the
If
Senate.
we repeal and reenact, all of that reenacted language would be
1622.
considered new and it wouldn't show up as bolded.
Mhm.
So I would need, I wrote this a year ago, so I would
It's
need to
amended
go
by the
back
Senate.
and
No,
look
we're
at.
taking that out.
I don't want to make a mistake here that we regret later.
Yeah,
That's why I think
Okay,
the
I see it.
safest.
Okay.
but where's the change?
This is the language. In
Change
the
is
Don't look
only
at the
in
change.
Oh,
section 2.
because it's, here's 2, Roman 310.
It's only in section 2, the rest of it appears to be the same.
All right, so,
We're doing this kind of on the fly, and I want to make sure we don't. make
yeah,
a mistake.
I'm not comfortable
Go with
with that. I understand what's going on here. at all.
So what we're doing is we're gonna add paragraph 2 on 1622 and replace this paragraph.
Paragraph 2 on 518.
Okay.
That's all we're gonna do.
That's all we're doing. That's all we're talking about.
So license
Exactly.
agent,
And the rest,
2 years.
the rest
Leave
is
the rest
Senate.
of the amendment alone.
Yes.
If there is a change, we're not picking up.
And frankly, to me, this is the harder way to do it, but it is the safest way to do it.
If we want to, provided, so it got rid of subject to restrictions imposed by, okay.
It only goes to 310.2, so in side by side, what we are removing is 310:14.
Where on the side by side is that?
So,
Page,
if we take
If we take section
Page
2 out of
four.
1622
Two.
and place it into
and swap it out
right here,
here, yes,
exactly what I heard.
yes.
All right.
Then this,
Representative Leckis?
Yes.
This is
remains,
what I would suggest.
we retain fidelity to this, yes.
Okay. We use section 2, 1622 language and put it into 518. Simple as that.
Okay, and so this, I'm looking at 1622 as amended by the Senate. And so you're saying section 2 is this, that doesn't look,
It's the same. Licenses shall be valid. No, you have the wrong one.
where's section?
Lines 2 through 7,
So it's actually section 1.
Well, I don't know what it is in.
This is amended by the Senate.
What I'm saying is use the 1622 language, whatever section it is in 1, I don't know, but it's section.
Oh, you're looking at
It's
310.
310.82.
Right, so this is the Senate, 1622 as amended by the Senate. So it,
310.82 to read as follows.
and so taking section 1, basically, out
Licenses
of
shall
this.
be valid. Well, yeah, but it's section 2. Or 2.
What's Roman 2? Okay. So basically, yeah, I'm just trying to get the right way to refer to it, and so to for Olaf. So what I'm saying is, if we took HB 1622 as amended by the Senate, section 1. Actually, it's all of, that section 1 is only doing that paragraph.
Yeah.
And then include that.
Yes, and that's the only change.
Right. Okay, so just to review, my understanding is that we adopt everything in the side by side. So the Senate amendment, the whole Senate amendment we keep except for section 15.
Yes.
Okay. We're going to add the language from the amendment 1610H.
Yep.
And we're going to replace the language in HB 518 as amended by the Senate, page 2, lines 14 to 18, with the language from 1622 as amended by the Senate, section 1, which is only that part.
Oh, no, not section 1, paragraph 2. We don't want to,
Lines 2 through 7.
right, that's all we want to do. We do not want to add section 1
Lines
where
2
we
through
say
7.
license renewal of lapse, blah, blah,
Okay.
blah. That's already in here.
I don't know if he has the version up with the numbers on it, but it's lines 2 through 7 on the amendment.
Yeah, I sent
Yeah, I'll have to get
Okay.
that with the number. Actually,
Alright.
did I get that?
Are you guys comfortable now with that?
Yes.
So you'll need to vote on that and we'll vote on
We're
this.
leaving in all of
Doug, everything
the
else?
medical reporting.
That was my only concern, was that
I
Okay, and just
Conflicting
the
language.
caveat, the committee members from 1622 had to remember to take that paragraph out of.
I'll be there this afternoon.
Okay,
I
we
won't let you
don't
forget.
want the same thing.
They don't actually have to take it out. As long as it's the same language, it won't be a conflict.
Okay, great.
That's why we're amending it to be the same.
Okay, that's fine. Perfect.
There will be no conflict, and then it doesn't matter which one's signed in first.
Okay.
Because we're parodying the language.
basically creating the redundancy.
Yeah, we're just parodying the language, and it doesn't matter which one's first or last, because it'll be the same.
Okay, and actually I've got the version now with line numbers, and what did you say for line numbers?
Lines 2 through 7.
Page 1, lines 2 through 7. And let me see if that looks right to me. Lines two, okay, right, that works. All right, I think I understand what I need to do, if we all agree.
I'm in agreement.
Okay, so if you guys want to go and vote.
Senate members, are you guys all good?
Oh, I think we need to caucus for about 20 minutes if that's, no.
We agree to that. too.
Okay.
Yes, we agree.
On the House side, everybody in favor of this?
Yes.
Yes.
Anyone opposed? No? Okay, deal.
Deal is made.
And I will go down to OLS to get this
Close the committee
drafted, and then I'll
conference.
write, I'm going to close the committee of conference on HB 518. Sure, thank you. All right.
Mm-hmm.
Relatively easy one, except for all the details, but.
Mm-hmm.
And, so Doug, so,
some concerns in the fact that basically protecting the safety and health of some of the patients, and you might have gotten this letter, but it created a certification requirement for some of the outpatient treatment providers, because according, there's actually a couple of letters. Currently there are 65 outpatient treatment organizations registered with Medicaid, and those DHHS contracts with 9. So they have no oversight. The remaining 56 have no oversight. So they had concerns about that. We don't want another incident like the the Sununu Center. So New Futures came in with that. And the second part of it establishes a behavioral health position within the DHHS Office of the Ombudsman. Now, I did have a chance to read some of the concerns from, or not concerns, but Jennifer O'Higgins from our hearing report. Where's she on? She did have detailed some of the points in this. So as far as I'm concerned, New Futures asked for it. And I know Senator Carson would like to see some of it, or if not, some of it, if not all of it, to go through.
And we have a representative we have Mr. Berry from New Futures. Would you like to? So the concerns that we'd like you to address, if you could, is how this would be managed within HHS. And I know that a representative from HHS is not here.
Sure.
And maybe you could also address the concerns that, for example, I would imagine that the certification program is to make sure that all the recovery facilities or substance abuse facilities operate on the same standard. And if they have to be licensed, how is it that we need this added? So that's the question.
Sure.
How, if we already have the individuals certified and they're supposed to be operating on the same standard, why do we need an additional certification program?
Sure.
I think that would help. Yeah. Okay.
Let's hear it.
Yes, go ahead.
There we go. All right. Thank you. That's it. All right. So, as you know, New Futures has been working to address substance use and addiction in our state for over 25 years. We've been working on this bill with Senator Carson and other supporters going back to last summer. Just to provide some clarity where this came from, you may have seen or heard where the 13th Step, which was an award-winning podcast series from New Hampshire Public Radio that detailed patterns and cultures of sexual assault and harassment with one of our largest treatment networks in the state. Let me be clear, the treatment network in question in that podcast was a residential treatment program, largely residential services, which are not covered by this bill because the residential facilities are already licensed. But what that podcast did expose was a sort of a long-held, a little-known secret within the substance use treatment world about a lack of oversight over another class of treatment providers being outpatient treatment in our state. For outpatient treatment providers, there is individual licensure for clinicians, which I'll come back to in a moment. But beyond that, there is no facility licensing. There is no facility certification currently. There is no oversight. And as Senator Birdsell mentioned, for a great many of these providers, there's no record within the state of where they provide, what class of services or what quality of services they provide or who they are. We really see that as leaving, these patients who are at their most vulnerable point being at risk for abuses or misconduct or at minimum substandard service, which is something that impacts not only their own recovery, but the quality of our entire treatment network across the board. We spend a great deal of money to prop up this treatment network to ensure these services are provided in folks, but it's really only as strong as the weakest provider. And we really want to make sure that everybody is operating by the same standards, the same qualities of care, and so on. And again, right now, there's no real way of ensuring that. as far as mentioned earlier, there is individual clinician licensure within the state, and individuals can be held responsible. But what we have heard word of around the state are organizations that will say play a little bit loose with the rules, in which they are crowding group therapy sessions far beyond the ratios that are considered to be best practice. They are employing recovery professionals who are not so far along in their own recovery that they are not supposed to be providing that level of support or services, which again leaves them at risk as well as their patients. If individual folks are the only people held responsible for this, if they are removed, there's still incentive for these organizations to just put somebody else in the same position to do the same thing, which leaves the clinician, leaves the patients at risk again for these abuses and misconduct. So this really is intended to plug that hole in sort of oversight or authority to ensure that the state can know who these providers are, where they're operating, and really try to hold them to certain standards of service in order to prop up their own service, and again make sure that our entire network, which again we work so hard to fund, is providing quality services across the board. And so to make sure that folks are getting the treatment that they need, and that we're making good use of the money that we are spending on our treatment services. Does that, I hope, answer some of the questions?
Thank you for being here, and thanks for taking my question. So, from my understanding, nobody's opposed to the idea of the bill, but still the House Health and Human Services Committee came out with a 19-1 recommendation for interim study.
Sure.
The one person wanting to kill the bill altogether. So the vast majority of the people felt like this needed more work, and I was assured by them that they plan on doing that work. Can you speak into the concerns that you've heard from that committee at all, and why they want to move this to interim study, and their
Sure.
concerns about this language, because we don't have anybody here?
I'm happy, yes, and I believe that my colleague, Ms. O'Higgins from DHHS is on her way. I think she's aiming to be here to answer some of these questions. There were questions raised within the House Health and Human Services Committee around who would be held to these certification requirement, what class of providers. There was some, I would say, some misunderstanding about this bill is really intended to apply to clinical services only. It does not apply to Alcoholics Anonymous. It does not apply to other self-help groups. That has not been spelled out in the language. That had not been spelled out in the language of the bill, because we thought that the reference to clinical outpatient services would suffice. But there were some questions, and again, I would say some misunderstandings around that. There was absolutely no intention here to apply to, again, AA, self-help, other non-clinical services like that. I did work with certain committee members on an amendment that ultimately did not get put forward on language that would clarify which classes of providers this would apply to, as well as what exemptions exist. And I'm happy to share this language with you if that would be helpful. It clarifies that, again, residential services are exempt because they're already covered by facility licensing. Individual practitioners are exempt because they're already covered by individual professional licensure. Again, self-help and AAA and other group programs like that are exempt because, again, that's just not in the intention of this bill in any way. I'm happy to share that. But that was the crux of some of the questions we heard.
Thank you. So that was part of the discussion, though, in Health and Human Services?
It was.
Okay, and at the end of that, you are not able to assuage their concerns that this didn't apply to those groups from the sounds of things, because they moved 19-1 to interim study. So it was part of the conversation, but it didn't resolve the issue.
The simple fact was we ran out of time. That it was supposed to be a second committee bill, and the deadline was that afternoon. We had the hearing, I think, was held 5 days before the deadline or something along those lines. And the simple fact was that we ran out of time to address the concerns that were raised. I was hopeful that this amendment that we had worked on would address them, but the committee felt that they just didn't have enough time. What I would say, certainly we appreciate the intentionality of the legislature in taking its time with this, but there's some urgency here. The longer that we have people out there attending these unregulated, uncertified treatment providers, again, the more at risk they are, again, for misconduct, abuses, substandard services, and again, the more that costs them individually, and it costs us as a state.
Having said that, do you have statistics as far as incidences in the licensed or unlicensed facilities that would indicate the urgency? So, you're saying there's urgency because there's danger of things happening. Is that happening at a prolific level outside of the Sununu Center, obviously, but in other areas, or we're just noticing that it could?
Again, it's impossible to know, which is part of why we're here, because there's no mechanism, there's no oversight mechanism, there's no ability for the state to track these things, to take those kind of complaints currently. That's what we're trying to put into place here.
All right, thank you. Yeah,
Sure.
Okay, Representative Gould, and then Senator Prentice.
Thank you, Senator Prentice.
Oh, no, Representative Gould, then Senator Prentice.
Thank you. Thank you. Thank you, Madam Chair, and thank you for taking my question. So I remember a few years ago an expose, and I don't think it was the NPR thing, but maybe it was. And I was praying somebody would be here with a better memory and more active in the field than I have been for many, many years. But it was about a young dynamic individual who created a very exciting program and about many workers that got involved and were really, really excited about addressing the very serious substance abuse issues we have in New Hampshire. But then a funny thing happened and money kind of got in the way, and the numbers were being increased and increased and increased and increased, and the pressure on the workers was becoming more and more intense. And it finally got to the point that it was very abusive to both the staff and the participants in the program. And I don't recall the name of the program, but I do remember it was a serious concern. What my question for you is that I'm really concerned about is that if we are relying on the licenses of individual clinicians to follow their requirements in providing services, but we have no oversight, zero oversight on the entity hiring them, we then are putting those clinicians in the position of having to be the oversight for agencies that pay them a salary. Is that correct? Am I understanding that correctly?
Yes, Representative. No, that's absolutely right. If there, and again, there's been sort of an unkept secret within the treatment world, and we heard this in testimony at the House, the House hearing, the Senate hearing, from all kinds of treatment providers that our best treatment providers in the state, or treatment providers all over the state, are serving patients who are coming from other programs that did not receive the level of care and support that they needed. And this makes it more challenging, more time consuming, and more expensive for these programs to be able to get these people on a path to recovery who have already been through, at best case, substandard service, at worst case, trauma coming out of some of these things. And because there are certain, and I don't think there are many of them. And again, we're going by anecdotes because we have an inability to track it. But there are some treatment providers in the state where there's just a culture of chasing some of the money that you're talking about. And let's make no mistake, there's a fair amount of money available through Medicaid, which, and thank God it is, that's what supports our entire network. But there are some folks who are driven more by the potential revenue than they are by care for patients. And to hold an individual clinician responsible for the culture of an organization that is out there sacrificing quality of service for the bottom line and for revenues is not only, I think, somewhat misplaced and a little irresponsible in a way to chase quality clinicians out of the field, in my view.
Thank you very much for that. I have another question somewhat related to make sure I'm understanding, or that my understanding is accurate. In some of these organizations, don't we have a mixture of licensed clinicians and kind of peer-to-peer, or sort of the self-help aspect that you were referring to? So that we would have licensed clinicians being held to a standard, an agency not held to any standard, and then self-help level kind of people that are not licensed, that are in there also not held to any standard. Is that correct?
I want to make sure I understand the question, but it certainly sounds, none of these things are mutually exclusive, right? You can, you do have some treatment center, provider organizations that provide outpatient residential treatment, and they will provide some level of recovery support, either in-house or either through a contract with a recovery community organization or something along those lines. So yeah, and some of them will do, provide just clinical treatment. Some will provide what I'm looking for, religious-based treatment, which is again not considered clinical, but it's another approach. So there is certainly a mix of providers across the board, but this isn't again intended to provide only to those folks, to those organizations that provide clinical treatment services, and not getting into self-help and others.
Last follow-up.
Okay.
Thank you. So thank you. I think that confirms what I'm saying. My point being that we have licensed clinicians who are sandwiched in some cases between organizations that are unregulated who control their bread and butter, their paycheck, their support for their family, and other sideline services that might be incorporated into the agency that are also unlicensed practitioners who are out there performing. Whereas if we had licensed providers and licensed clinicians, these self-help sort of aspects of a program would have two layers of supervision, not a clinician stuck in the middle.
And if I can add, that's really the intention of the second provision of what was Senate Bill 495 related to the position with the Ombudsman's office, is to ensure that there is a dedicated sort of place that staff members, as in addition to patients, can go when they are witness to or being asked to provide substandard service, right? That they we want to make sure that we have somebody who is properly trained and equipped to respond to those kind of complaints, because again, we know it's out there, and hopefully if we put the certification and regulatory system in place, there will be more complaints coming in.
Senator Prentice.
Thank you, Representative Broda, and thank you, Jake, Mr. Berry, for taking my questions. So you're talking here about, we've got these providers that we've got these providers that are out floating between different, what would currently be defined as facilities, providing care, but the treatment services, but the centers or facilities that they're providing treatment at are not licensed. So there's no regulatory oversight, but I'm thinking I'm repeating what's already been said, but I'm going somewhere to make sure I've got this clear. So we have the providers, but no mothership to be tethered to from a licensure and a quality control perspective.
Correct. If there is a complaint filed against, right now, if there is, again, substandard treatment services being applied to it, we're not sticking to clinical standards and so on. The only complaint that can be filed is against the individual practitioner, which again does not address the issue if there's an organization that is inspired to purposely evade these treatment standards. And I hope this answers some of the questions, Senator. But again, there are we know of some provider organizations that are motivated by revenue, by bottom lines, as much as they are, or more so than they are patient care, which leads them to kind of flout treatment standards. And it is not an issue in the individual clinician, it is an organizational issue. So if there is a clinician that is removed, they would potentially be placed with someone else who will again similarly flout those service standards and leave patients at risk. Does that answer the question?
Yep, it makes sense to me. So follow up. So Mr. Berry, would it be your position that alcohol and drug use are public health emergencies, public health and public safety emergencies in this state?
Certainly so, and I would think that by the amount of time and resources that have been devoted in the state over the last 10 years to build a treatment system that is capable of, I think that it seems to me the state as a whole recognizes this as a public health emergency. And again, I would argue this is just part of the natural maturation of the system we have tried to put in place to make sure that we are protecting everyone in our state, especially the most vulnerable among us who are in need of these services. And again, to make sure the money we're spending is being well spent and well guarded.
Thank you.
I will note that that Ms. O'Higgins from DHHS is here now as well. and
Would you
can
like
answer
to
questions.
join Mr. Berry at the table? That would be great. So I'd like to take the conversation after listening to everybody into this vein. So the state is invested in drug and alcohol abuse, substance abuse, correct? And the facilities receive money for those to support that the work that they do. But those facilities are independent of any kind of certification or registration that we have within the state. So although we give them funding, we really don't know their, let's just call it their performance record or their treatment record. Is that, or the way they treat people, is that correct?
So this bill actually just expands those that even don't have state funding. So currently, if you receive state funding, there is some amount of oversight or the ability to certify those who receive funding. But we know there to be at least 65 outpatient facilities registered with Medicaid, and of those, only 9 receive funding through the state. So the oversight piece doesn't exist for others that operate as an outpatient clinic.
And if I can note, those are only the ones that take Medicaid. When we think about all of the, those that do not, they are not on the map anywhere. There's no contract, there's no record within the state of them whatsoever.
Okay. Does that lead the committee to any questions that they might have in their mind? Yes, Representative Bertzel?
Okay, thank you very much. So I'm looking at the bill. This bill requires that, do we not already have an ombudsman department for this particular?
We do. So anything that falls under DHHS can fall to the current ombudsman, because this bill would be inclusive of those outpatient facilities for whom do not receive state funding. Those services would then fall under the current ombudsman. This bill does add a position that would have more expertise in the area of behavioral health within the existing ombudsman's office.
Follow up? So, and I'm looking at the language, and it says, subject to available funding, the department shall designate within the office of ombudsman a person as behavioral health. So they'll only assign it if they have the funding for it.
Correct.
Okay, thank you.
If I can note that, we should note that there's no appropriation attached to this bill. There's no dollars and cents. Really what this does is task the department with going through rulemaking, with creating the certification standards. This is beginning a process that will ultimately result in the certification authority, but this is the beginning of a process.
Representative Simon?
Thank you. There's no appropriation per se to it, but it does give the ability to levy fees on facilities, correct?
Yes, so if we were to adopt the rules, but because there is the contingency language in there of subject to available funding, we would have to know, the department would have to know that we have the staff to actually certify these facilities and oversee their quality before we would adopt the rules, right? Because we wouldn't want to start saying you have to be certified if we could not understand the quality of your programming. Then we would be just certifying places and sort of giving a false sense of security that they have oversight. Mm-hmm. So until such time as we would have the staff to do the oversight, then we would adopt those rules. So again, like to Jake's point, it's the baby step of there's so much details that need to be figured out about what would be in a certification program that it allows us to start to work with facilities to figure out what needs to be in the rulemaking. And then at such time as there is available funding, to have the staffing to certify and oversee the quality, we could implement.
Senator Bertzel?
One last question. So let me just get this straight. So this is just opening up the door to looking at the rules and setting up the process, and then possibly next year during the budget process, putting the funding in. If everything's lined up at that point, then next year during the funding budget process, putting the money into the budget for this position, correct?
Yes.
Okay, thank you.
So if I could follow up with that. This is important. I think this is an important part of the discussion. If this were to be added, what it allows the department to do, the agency to do, is to start putting together a program. Because without that, you really can't ask for funding because you won't have anything to ask for, right? But if you don't get the funding, then this can't happen because you won't be able to fund it. Okay, so my question is, if we have 65, if we have 65 registered facilities that take Medicare and 9 are funded by the state, so we have purview over those 9, that means we have 55 that don't. What's the incentive for those 55 what would, is it just because we're putting it in statute that they have to do it, and then what would happen if they didn't?
Right in the state without this certification.
Okay.
So the incentive is to practice.
Okay.
But ultimately, that's also just, those are the Medicaid, those who take Medicaid numbers, again, are just giving us an estimate of the scope of work that's happening that we're unsure about. So I think Mr. Berry also had mentioned how just understanding the landscape of treatment services is an important step forward for New Hampshire, because when we get a call from, someone who needs services, when we don't know where they're all located and the quality of them, it's very hard to make a referral. So those who we do know who receive state funding, who we work closely with and collaborate with today, are who is going to receive all of the referrals through those state programs. But understanding the landscape and quality of treatment services also expands where we can refer people. And even if they don't receive, take Medicaid, there are lots of folks who have other health insurance who still need treatment. So expanding our understanding of the landscape of care goes a long way for us as a state as well.
Okay, that's helpful. And I really believe Representative Simon has a question.
Thank you. I appreciate it. So this ultimately, if I'm understanding it correctly, is a facility license. It's certification, but it's similar to a license. In order to be able to hold these facilities accountable to certain standards. Now, I'm assuming, even though they're not certified under the state of New Hampshire, are there things that they could do that would be considered illegal and criminal from a facility standpoint that the state could step in? If somebody came to the ombudsman from one of these facilities and says this is happening in this facility and it's illegal, that the facility could still be held accountable to that illegality. Is that correct? Or?
Multiple layers exist in terms of the clinician's license. So the licensing board plays a part. If the facility's residential, it's already licensed. So we're talking about the outpatient piece. So if a facility is licensed, then there's a way to, issue a complaint that would be covered by both the ombudsman and our licensing unit. If this facility receives state funding, yes, it falls under the ombudsman and the Bureau of Drug and Alcohol Services. But the other operators who don't fall into those categories exist without that oversight. There is the way that you could report the clinician to the licensing board, or criminal activity, of course, could be reported to law enforcement.
If I could add, Representative, but certainly I think criminal activity is not the only standard here. In the worst cases, it certainly is. But we're really what we're trying to talk about is quality of service and ensuring that people are being held to service standards that, again, help people to achieve their recovery, help these and help organizations all across the network do their job of getting people into recovery. And again, which helps individuals, but also assures that our state investment in this is money well spent, right?
So I understand that the data is a problem, but it would be helpful to me in making this decision to know that the facilities that are presently under the jurisdiction of the department and have oversight are producing per capita better outcomes for their patients than those who are not.
We have no information whatsoever about those who are not.
Right. So, but what you're asking us to do is to then give you authority over all of them when I have no indication that the ones that are under your control are doing better than the ones that are outside of your control.
Correct. We have, again, we will have no idea as a state about the outcomes of those that we do not have a contract with without granting some authority.
So is there a step in between where we start to gather information before we just change the entire system?
Sure.
Again, we can certainly talk about that. I don't know how you gather information from these programs without some level of contact connection, some level of regulation of what we're talking about here, I think. And again, that's the very intention of this. And I would say in the absence of this data, all that we have are the testimony and experiences of the service providers themselves. And again, they have showed up throughout this process to say they desperately need this, they desperately want this. This is not opposed by a single treatment or recovery or healthcare organization in the state that I'm aware of, because they think this is absolutely essential to ensuring the level of service across the board.
Thank you, guys. Appreciate it.
Representative Prue has a question.
Well, kind of a question and a statement. So to be able to get the information you need, you're going to need authority given to you by us. So you can collect that data and actually make them give you that data, because they're not going to give it if they don't have to, I would assume.
I think that's very much part of the intention here, for sure.
Right. So you need the authority to collect the data to make sure they're doing what they're supposed to and providing a level of care to the standard, right? I get that. Just wish it wasn't on my bill.
So let's park this for a second, because this is something we'll think about. And we're not going to be done by 12 o'clock, I doubt. But let's go to the second bill that was added to this, which is independent from. Did you have a question? No, please.
Just in following up in the line of questioning, just want to go back to the threat to public health. So let me ask this a little bit differently. These folks who are seeking and or receiving treatment, correct me if I'm wrong, but I believe what I heard you say is that they are in jeopardy or they are in danger because we have no true oversight over the organizations, just the providers. And there's an inherent problem in that system, correct?
That's our feeling, and certainly the feeling of treatment providers around the state, for sure.
Okay, thank you.
That prompted me to, that's my concern. And my concern is twofold. Number one, we want to protect the public. Number two, the state is investing a lot of money. And if we are limited to the number of facilities that we can refer people to, that really impedes the progress that we have towards resolving this issue. But my question is, are there other states that have this type of program? And might you tell us a little bit about that, what path they took and what the results were from there? Because it's not going to be like the people of New Hampshire are uniquely different than the people in another state, right? We're all people. So do you have some information there?
Yeah, so I think generally substance use disorder care has been largely unregulated throughout the nation. So New Hampshire is not unique in having some of these same challenges. And there are certainly states that have certification or licensing that are inclusive of outpatient care. And we would be able to look at examples of that to use for rulemaking or inciting for you all to review to figure out our way forward in New Hampshire.
Okay, does anybody, yes, Senator Pearl.
I don't actually have a question. We're going to have to be done here by noon. We all have other places we have to go.
Okay, then let's just hop over then to Senate Bill 217.
Right. Sorry to rush us along, but we're
That's
on
okay.
a really tight schedule today.
Well, yes, I understand. So, Mr. Hawkins, do you want to come and so what was so this bill was actually amended by the House Education Committee from an incentive program to a grant program. And then it was, it met its untimely demise in the House Finance Committee. But I think perhaps we can explain to the committee or maybe the House the Senate can speak to why they added it. And then maybe Mr. Hawkins can speak to the fact that this is something that's paid back, right?
I'm sorry, something that is, I think,
This is a loan program that's paid back, is that right, or no?
it is a loan repayment.
Right,
Yeah.
okay.
Well, this was, I believe, Senator Fenton's bill, if I'm not mistaken.
And I'm happy to speak to,
You're on education.
yes.
All right, we'll let you take this part.
Okay, thank you. So whether it's a grant that they have to pay back, or a loan that they have to pay back, an incentive or a grant, the teacher shortage committee or commission made this as a recommendation that, you know we have a shortage of educators, of teachers, and Senator Fenton has been working on this for almost 2 years to try to get this into place to support, and it's primarily targeted for the more rural districts in this state. And it talks about, the rural districts in the state, the size of the schools. I mean, all of that is in here, and, we're looking to resuscitate this because of its importance. We know we have a shortage of teachers. We had a commission, I think it was a committee, so I'm not trying to use those interchangeably. I wasn't on it, but Senator Ward chaired it, and former Senator Khan was on it. And this was a key recommendation focused on the more rural areas of the state. So it's about making an investment, whether we're making it as, offering it as a loan to do payback and, through an incentive program or a grant. We need to do something. Okay. And so maybe finance was concerned with the money, but, well, that's their job to be concerned with the money and the appropriation. But we've got to do, my opinion is we've got to do something. This is critical. We know that it is, and we just keep kicking it down the road. So here's its final stop this year.
Yeah. So I have a question so my comment on this was, is this Senate version the one that has the loan as opposed to the grant?
Yeah.
Because would the Senate object to this being the House version as opposed to the Senate version? And I'm sorry, I didn't think of this question.
So this looks like it's an incentive. See it as a.
Okay, I'm sorry. It's an incentive, and the House changed it to a grant. I apologize. The word was incentive, and they changed it to the word grant. To qualify for the loan repayment assistance.
Senate version is educational loans.
Right. And right, well, but there's a dollar. Yeah, arguably yes. So and the budget, and really this is another. So my thinking on this is that because we've put a dollar in there, right? And if we don't fund the fund, it doesn't happen. And so this becomes a decision of the finance committee, and this is actually a policy, and the policy was passed by the committee. So I'm in support of this bill, this portion of it, because it becomes a policy, then therefore needs to be funded, and whether or not finance funds it depends on how much money we have, and that becomes a financial issue. Does that make sense to everybody? Are we all in agreement with that part? It was a beautiful soliloquy, if I might add. So what I was thinking was, because this is really a policy issue, this is really setting up a program, which is a policy issue, and the House Education Committee passed this, right, which is unusual for the House Education Committee to pass something that they agree on. It's been a tough year in education. And so I think that I'd like to honor this request, but I'd like it to be the House version, if we could do that. And then we will leave it up to finance next year to put it in the budget. And if they choose to put it in the budget, they choose to put it in the budget. If they choose not to put it in the budget, it doesn't go. So, but at least we don't impede. Does that make sense? I got a yes from you originally.
So, Representative,
No, it has $1 in there, yes.
Time, you're on the similar track to I was. I mean, this should be a budget year issue, in
Yes.
my opinion.
Yes.
Policy.
The
Policy is.
but the policy could go through.
Yes.
I don't have an issue with the policy, I just have an issue with the funding that we do in off years, in general. I mean, I'm not having an issue with this bill, but if the House was agreeable to putting the policy in and leaving the funding out, I'm not sure that we as a Senate would have a huge issue with that, because then we could take it up in the budget next year.
So,
Oh, sorry,
How
Jim.
about we
I'm sorry.
make this just 2 bills instead of 3?
Just calm down. Wait. Okay, we are, don't worry.
Well,
can
I'm worried.
we
I know,
just?
but don't.
Oh, okay. So the Senate version was at $1. I guess we didn't put any money in it.
No, it has always been $1. So there's no money in here. We're just saying that this is,
Right.
this is a policy.
Position.
Right.
What?
If there's no,
I'll
sorry, Regina.
I'll give the $1.
Okay.
No,
What's
I-
the
I-
difference between the Senate?
Doesn't really. Go ahead, sorry.
The Senate budget and the House budget?
No,
No,
the
the
Senate
versions
version
are
and the
different.
House version.
The House version must have had money attached to it.
No.
No?
House version turned it into a grant as opposed to an incentive program.
Okay.
That was the only difference. Is that correct? Mr. Hawkins can help us here.
Yeah, I think you essentially described it. The idea was the same. The difference just being the Senate policy being a graduated loan repayment. The Senate's didn't stipulate loan. It was more of a incentive retention grant, same amounts and everything like that. But it didn't ground that into a repayment of a loan. So it looked a little bit more like, you know, in HB2 this year, you did an incentive for a computer science. It looked a little bit more of like that, I would say. I mean, but the idea was the same, you know, trying to help retain and recruit educators in rural and underserved areas.
So I had a long conversation with Representative Cordelli, who's a co-sponsor on this bill, and he was the one that amended it in House Education, and he called it more of a grant type program as opposed to an incentive program. But the concept of a policy to attract teachers to underserved areas is similar, and he supports that. So, let me try to find the House.
So if we were to give you that change, would
Yes.
you support the remainder of the bill? As
For Senate Bill 217, we would add
would you
217.
support the remainder of 1079 as the Senate amended?
Okay, so the 1079 amendment, how are we feeling about, this is another one where we have no money, and it's a policy issue, because this is not funded right now, correct? We're talking about Senate Bill 495, so we're going to so what you're saying is,
If we agree to amend and take the House language of the last part,
yeah.
will you give us the rest of the bill as we amended it?
Yes.
You
My
will.
vote is yes.
My concern, we have 3 different moving parts in this.
Yeah.
2 of them were rejected by the House. 1 of them was accepted by the House.
No, one of them was put in terms that was rejected.
What? The original bill was interim study?
No.
No, that one was accepted.
495 was interim study.
Yes, but the original bill was moved out to pass. We passed that bill, right?
Yes.
And they've also passed that. bill.
Yes.
Right.
Yes, we have.
And to me, that's an important piece of legislation. I worked very hard on that bill, as Representative Pearl knows, and we worked to get that through. My concern on the 1079 language is, first, bipartisanly in the House Health and Human Services Committee, they moved 19.1 to interim study. in my few minutes of having the discussion here, I feel like it's more complicated than just a straightforward, here's a good program. Not that I'm opposed to the idea of obviously improving substance abuse, but if we attach that and we attach this to bills that the House rejected, we can agree to it here. But if it goes to the House and gets shot down because some people don't like the education component and some people don't like the substance abuse program, we're going to lose all of it. We're not going to get any of it. And I'd hate to lose the original language, and we can't control that. Like I have no control over whether or not the House is going to accede to that language. So I feel like we're putting at risk an important bill when Health and Human Services in the House is very committed to working on 1079 to come up with language that will work. And I mean, I actually like the education component. I'm not opposed to the education part of it at all. My concern is, the saying goes, you know, like you need all kinds of reasons to vote for something. You only need one reason to vote against it. And I'm just worried that we're setting up opposition to the underlying bill by passing all of it. So I'd be agreeable to leaving, on principle, I'd be agreeable to leaving the education component in. I'm personally opposed to leaving the middle section in on 1079 to the point where, not because, once again, we need solutions to that problem, but I'd probably need to be replaced if the committee wanted to pass that through.
So the thing I would say is I understand your concern, and there'll be a filing period coming up in 6 months where if this does pass, that tweaks to it could be made relatively quickly, within a year. And so, you know, I don't think there's a danger, even if there is some minor tweaks that need to be done to the middle section. I think that the ability is there. HHS won't have things in place, rulemaking done before we could actually put another bill in and change it. You know, the HHS committee could certainly do that. And those changes could probably occur before rulemaking ever got going and the program was even stood up. So if there's real concerns about some piece, some element of it, there is an opportunity to correct it. I don't share those concerns, but if there are members of the House that feel there are, and Health and Human Services wants to take that on, they'd have the ability to do so.
Well, my main concern is that there appear to be a lot of members of the House that hold that concern. And I'm just thinking numerically, you know, as far as getting something done this year.
Well, that's your selling point on the floor.
But
I just wrote your floor speech.
I might add, I think what was attached is maybe a little bit different than what actually went through Health and Human Services, because here it's only putting the rules together. It's not adding the person in. We're just putting the rule. We're just allowing the Health and Human Services to put the rules together. We're not implementing the program as of yet.
Well, I mean, and I did have a confusion on this point. Maybe somebody from the Senate can help me out on it. Let me find the page real quick, sorry. Because I understand that we were putting rules in place, but part of that was...
If you're concerned about, the language in there, so if funding available, we can strike that and just leave the.
It's not, it wasn't funding per se, but if you look on page 14, Roman numeral 4, it says all fees received from certification under this section. So I'm assuming, it's an assumption that means that during the rulemaking process, they'll be granted the authority to levy fees against the facilities that they're overseeing for certification. And it shall be kept in a non-lapsing fund known as the Substance Use Treatment Certification Fund. So we're going to allow them to set fees. We've put no caveats to what those fees are. At least with OPLC, it's 25% above operating cost, your caps. There's no cap here. So, I mean, maybe we could do something with that, but there's no cap here, and it's a non-lapsing fund with no cap to the non-lapsing fund. So it's a fund that money can go into with no limit to it whatsoever. And I'm not sure.
Representative, I don't see anywhere in here where it authorizes them to put a fee.
What's page? Well, help me out. That's what I'm saying. Maybe I'm confused. You can page 14, Roman numeral 4.
Can we bring HHS back?
Yeah, I'd love to. Yeah, I need clarification on it.
Yeah.
It says all fees received from certification under this section.
You're correct. That is there. But
Yeah.
May I ask a question?
Of course.
May I ask her?
Oh, yes, you may, sorry.
Does this language allow you to assess the certification fee?
So I do think it would if we adopted rules on this. And so, but until such time as we had the staff to implement the certification, we wouldn't adopt the rules. I think if the rules are adopted, the fee, the details of the amount of the fee, and if there was a cap on that and all of that would be worked out in the rulemaking portion, which we intend to do with providers. So we've started that process of talking with providers about like what would make sense. We obviously have a big stake in the game for their financial viability. So we need to be careful to not, like, we need to make sure that there is adequate treatment in our state. So we're not looking for a fee that would then put them out of business, right? It would need to be on a scale based on their size and all of that as well. So that's some of the rulemaking that would need to be done. That's where a lot of that detail happens.
I read through this pretty quickly. I see no place in here where it authorizes you to set up a fee schedule. Maybe I'm mistaken and I'm missing it.
I
but I'm
think
not
it
seeing
does right there.
In rulemaking, when they say they can set up a fee, that's part of the fee schedule is in the rulemaking.
And we're not providing any oversight to that whatsoever. And so I understand.
Well, wait a minute. We are providing oversight because GELCAR does have oversight for that, right? So we do, and as a member of GELCAR, I can tell you that we are very, very keen on that type of schedule because we deal with it with OPLC all the time, and we are very concerned about fee schedules and agencies setting fees. So I do think that would be an area of concern to GELCAR and the agency and the GELCAR department, the Administrative Rules Department. Gould.
Thank you, Madam Chair. So could we just add a line in here that, are we all in agreement that adding a line about a cap on the fees or something to satisfy those concerns? This is my first committee of conference, so it's a technical question. Can we add language?
So I think my concern with that is we'd be really just throwing a dart.
Yeah, we are.
We'd have no idea what to do with that. I more trust GELCAR to look at it and assess the program correctly when they have the time to do so, more than us today sitting here and deciding that.
So could we add a line about the GELCAR process in there?
That's already
No.
That-
Okay.
So let me just explain how the rulemaking process goes. If the agency had the authority to implement this program, they would work with their providers to put together the rules. But there would be public hearings on those rules, right? And there would also be review of those rules by the Administrative Rule Department. And then public comments and the comments from the Administrative Rules Department are put together and presented to GELCAR. And GELCAR can object. They can express their concerns. And one of the things they can express their concerns of is the fee. So all that stuff has to be justified and has to be supported by statute, right?
Madam Chair?
Yes.
So my concern was, I mean, we all know the process, but referring to Representative Simon's concerns about the full House understanding that was where my question was, could we put something in this language that would reassure people? I mean, we face this all the time, is the ignorance on the regulatory process. And even though we understand it and that passing a bill doesn't give everybody willy-nilly access to run out and start doing, we know other people don't understand that regulatory process.
Madam Chair?
Yes.
We want a 5-minute caucus.
Absolutely.
And then we'll be right back.
Absolutely. And one of the things I do want to mention is that in the Health and Human Services Committee, Representative Weber did put together an amendment that was acceptable to the Democratic caucus, except for one person who really didn't understand the fact that you could have licensed people with unregistered facilities, right? But I think that's an issue that I can certainly clear up with them. So we do have an amendment if Representative Berry wants to discuss it when you go back. But I just want to give you that information. I think this is important, but I'm trying to keep everything in the balls in the air without having one plop on the floor and break.
All right, we'll be back in 5.
Okay, so let's use this opportunity to talk. Let's use this opportunity to talk. Senator Pearl.
You're going back to my past. Well, Madam Chair, we've caucused and we've recognized that the concern that is on the House floor about the underlying Bill 1079, and we certainly want to make sure that gets passed and give it every chance we can, because it's very important. I guess my question to you is, can you provide me a degree of assurance that Senate Bill 495 will actually have some interim study work from the House HHS committee?
Yes, you have my word, and you also have the word of Representative Simon, who is, so you have a Democratic word and a Republican word that we will push that, because we do think it's very important.
As way of reassurance, one of the higher ranking members of the committee I spoke to on that said that they plan on doing a tremendous amount of work on that. They really do want to get it right. And this person would just tell me straight up if they wanted to gut it and kill it and just leave it off on the roadside. They'd be like, no, we just want this thing dead. This person would tell me that in a private, confidential conversation if that's what they actually wanted, because they'd want me to do that here. But that wasn't the feedback that I got, just that they ran out of time. They really wanted to vet this more closely and get it right and make sure that it was done correctly, and that it was a true interim study, not a soft kill.
Well, with that, I think that we could be, I'm sorry.
So, and I also spoke with Jake and Jenny. They actually have, Jenny does have some homework that she has to do kind of in advance, working with some of the providers. So I told them, and I gave them my word, that we would do it in a step-by-step process, not eat the apple whole at one time, and just start with the rules and set up the program. So we can work together.
Perfect. Keep me in mind for that.
With that, the Senate would be agreeable to the original language of 1079 and the last portion, and I'm sorry, I don't have the 217, that language being added to 1095, and we'd be in agreement with removing the language that was from SB 495 from the bill.
Okay, so I don't want to push my luck, because this, so far we're going
2 out of
well.
3 ain't bad.
Yeah, so, but you're talking about the Senate version of Senate Bill 117 as opposed to the House version?
217.
217, Senate Bill 217, the Senate version, as opposed to the House version?
I don't know that we have a concern one way or the other.
Yeah,
If
I don't
the-
think, because it, grant versus, whatever was that?
If you're more
Yeah.
comfortable with the House version and
I
that
just-
helps you on the floor, then we're
Then
okay
that's
with
what we
that.
have to do.
Okay, but that's great. So it's this House version of Senate Bill 217 that came out of the House Education Committee and 1079 as submitted.
Correct.
As amended by the Senate,
Yes.
if we did that, other than, removing the, I don't remember if we made an amendment to that. We did not.
You
Okay.
didn't.
So yes, so the House version of 1079 and we'll accede
And the
to
House version
Of
of 217.
Yes.
We'll agree to remove the other portion. from-
Okay, thank you. So I have agreement from the Senate. Do I have agreement from the House?
Reluctantly.
Yes.
All right.
Okay, thank you. This concludes the Committee of Conference, and excellent.
Thank you.
Thank you, Madam Chair. Nice job.
All right. Good afternoon. All right, Walter. All right, House Bill 1622 on administrative rulemaking and license renewals, et cetera, et cetera. We mostly agree with the Senate amendment. We do have a couple of issues that we'd like to bring to your attention. Yeah, it's the cannabis group. They're going to be loud. Section 2 has, which is RSA 310A Roman 2. The language is fine, but it's already been included in House Bill 518 as of this morning. So we'd like to get rid of this, if that's agreeable with you guys.
I don't mind if we do, but is there any issue with having it passed twice just to make sure we didn't make a mistake?
Well, if we did make a mistake, it would be bad because it would be random chance on whether the good version or the bad version came out first.
Right, but no, I'm fine with that. I mean, Representative Lekis, I just haven't seen the language. That's why I was hesitant to remove it.
Oh, well, it's.
No, I haven't seen the amendment that he's drafting. That was just to make sure it was correct.
Since you will be signing it off this afternoon.
Both of them I have to, so.
Okay.
I'm fine with that. Do you have any
Okay.
objection to that? We took that exact same language and amended House Bill 518.
Yes. All right, and then skipping on the page side by side over to page 7, there's the version of how the comments were to be incorporated in the rule. I have a draft here, copies for everybody. That that spreads out, and what does it do? It explains that the comments are uploaded, duplicate comments may be consolidated. You know, when you say we've got, 157 copies of this email from the Sierra Club or whatever, or the gun group, there's no need to post them individually. Or if 7 people write separately that, this rule's pretty good, but I don't like the fine in section 12, you just consolidate. And then vulgar or inappropriate testimony may not be published. It's just for discretion. And adds that comments received as video or audio files shall be available in that format. They don't have to transcribe voicemail or anything like that, but if somebody sends them a file, do it that way. And then on section E, I got some very nice language from the Jelcar staff that says, a report of public comments received on the rule shall be created. The report shall indicate how the comment was incorporated into the final rule. If the comment was not incorporated into the final rule, the agency shall provide a detailed explanation that includes the facts, data, interpretations, and policy choices that justify why the adopting agency did not amend the rule, which I think is a lot clearer than either the House or the Senate version. And
that's different than what you had proposed here?
Yes, yeah,
Okay.
Yes, this was my attempt at fixing the House and Senate versions, but that one's much nicer. It really gets to the point.
Okay. We would be agreeable with that.
Okay, good. And other than that, that's all the changes that we would be requesting.
So essentially what you want to do is use the language in 2272, except the final section, you want to replace it with this?
Yes. And delete section 2.
And delete section 2.
Because it's a duplicate.
Oh, yes, with the,
Yeah, not the final sentence of that, no, you'll only need to mention the duplicative remarks once.
Then I think we're good.
Okay? All right,
yep. I think
agree? Agree? Okay. We're going to the Senate version with a second amendment.
With an amendment, yep.
Yes. The other changes in the Senate amendment are perfectly acceptable. All right.
So Senate version with amendment.
Right.
And I wish they all went this easy.
Well, the Senate members had a bit of a deadline, so we. All right.
All right, so you'll take care of
I'll,
getting this
I will
filed?
write the amendment and write the report.
Perfect.
Okay. Thank you very much.
Pleasure doing business.
We try. Have a nice trip to Manchester.